So welcome again to this Legal Aid New South Wales Law webinar, Legal Words for Interpreters, Mental Health and Housing Words. My name is Kerry Wright and I work in the Community Legal Education branch at Legal Aid New South Wales. I'm here today first with Bridget Barker and Olivia Todd-Hunter, who are civil lawyers at Legal Aid New South Wales. We'll be joined later in the second half of the webinar by Joanne Kwan and Penny Adams from the Legal Aid New South Wales Mental Health Advocacy Service. So to begin, we would like to acknowledge the traditional owners of this land. We would also like to pay respect to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending today or watching the recording. We're going to do a quick poll to start off with, just to get an idea of your experience as an interpreter. So I'm going to launch that poll for you now. So the poll is, how much experience have you had interpreting for civil law matters like housing tribunals or mental health tribunals? A lot of experience, a little experience, or none yet, but I'm interested. I'm also aware that some of our audience are not interpreters, so you don't have to participate in this poll, but thanks everyone who is participating. So I'll close that poll and share the results with Olivia and Bridget. So you can see here, we've got 44%, a little experience, 28% a lot of experience, and 28% none yet. So we've definitely got a good audience, good mixed audience here today, Bridget and Olivia. So that's good to see.
Yeah, that's great.
I'll hide that now. So Bridget and Olivia, do you want to tell our audience a little bit about your work as civil lawyers at Legal Aid New South Wales? Do you want to start, Bridget?
Yeah, sure. I'm actually based in Lismore in regional New South Wales, and I work in the civil division as a solicitor doing a range of work. But at the moment, I'm working for the Community Legal Education branch in Legal Aid, and that's why I'm involved in this webinar today.
Thanks,
Hey.
Bridget. And you, Olivia?
Hi there. I'm Olivia. I'm speaking from Wollongong, and I pay my respects as well to the Wadi Wadi people of the Darrell Nation, whose nation and lands that I live and work on. I've come from a background in housing, so doing tenancy advocacy, and then I've just moved into legal aid in the last year or so, working on the south coast of New South Wales, mostly doing housing law and homelessness, or helping to prevent homelessness or helping homeless clients. So that's my background.
Great. Thanks, Olivia. So again, for those people who have just joined the webinar, just to remind you, there are 2 handouts on the control panel for you to download today. These contain the words that we're going to be talking about today and the definitions of those words, and also some space on those where you can put your own notes in. So, and also just to remind everyone that throughout the webinar, our presenters are more than happy to take your questions about these words that we'll be talking about if their definitions aren't clear. So I'll just take us back to our presentation. And this is what we're going to cover today. We're going to cover the Australian court system, legal words and concepts used in civil law, what is civil law, where civil law matters are heard, people in tribunals, words used in tribunals, civil law document words, housing, tenancy and renting law words, mental health and guardianship law words, and of course answering your questions. So Bridget, you're going to start us off having a look at the different courts and tribunals.
Yes, that's right. Thanks, Kerry. So this diagram is just to help you get an understanding of the fact that there are 2 separate court systems that operate in New South Wales. There is the state court system and the federal court system. Starting from the bottom of the state courts, the way that the diagram is set up is to show that there is a hierarchy of courts. So the lowest court in the New South Wales court hierarchy is the local court, and then the next court above is the District Court, and above that is the Supreme Court. In the federal system, the lowest level is the Federal Circuit and Family Court of Australia. It was previously the Federal Circuit Court and Family Court were separate courts, but they were recently merged. And then the next in the court hierarchy in the federal system is the Federal Court. And if you have appeals from either the Federal Court or the Supreme Court of New South Wales, they would potentially go to the High Court of Australia, which is the highest court in the Australian legal system. Off to the left and the right of the court diagrams are state tribunals and federal tribunals. We'll talk in more detail about the state tribunals today because housing matters and guardianship matters and mental health matters are dealt with in different tribunals in New South Wales. So the arrows show where appeals would go from a lower court in the hierarchy to a higher court in the hierarchy, and from the tribunals to the courts. A tribunal is a different body to a court. It is a body that resolves disputes between parties, but it isn't a court. However, a tribunal can make orders that are legally enforceable. An example of a state tribunal is the New South Wales Civil and Administrative Tribunal, which can decide cases about housing or tenancy in New South Wales and also about guardianship matters. And as I said, we'll talk about these further later on in today's presentation.
Okay, thanks, Bridget. So we'll now move on to some words. Do you want to take us through these first set of words?
Thanks, Kerry. Yes, so these are some basic legal words and concepts that you may come across when you're interpreting in court or interpreting a solicitor with a client who needs your assistance. So instructions are what your client tells you as a solicitor before taking any action on behalf of a client or making any decisions. A solicitor must have instructions from their client. This is when a client tells a solicitor what their legal problem is and what they want to happen after a solicitor gives them advice about what their legal options are. A solicitor may suggest a particular course of action, but it is up to the client to decide if they want to take that action or not, and they instruct or tell the solicitor whether or not to go ahead. The next word is confidentiality. Confidentiality is what happens when you say to someone will not be told to others unless you agree. Lawyers or solicitors who see clients must keep their client information confidential. They can't talk about what a client tells them without the client's permission. They can't tell courts what their clients tell them without their client's permission. There are some very rare exceptions to that, but on the whole, a solicitor has an obligation or a duty to keep what a client tells them strictly confidential. The next concept is privilege. Legal professional privilege protects confidential communications and confidential documents between a lawyer and a client that is made for the main purpose of the lawyer giving either legal advice or professional legal services to the client. So that is a concept that protects what happens between a lawyer and their client and documents that are created. The next idea or concept is precedent. This describes how the system of law works in Australia. Decisions made by higher courts in the court hierarchy that I described in the first slide are binding on lower courts in the same hierarchy. Decisions made by a court can be binding also on a tribunal. A decision made by an appeal court or tribunal will bind a lower court or tribunal. This system of precedent ensures that like cases are decided in a similar way and makes the legal system reliable so people can know and understand what the law says about a particular type of matter. The next term is statutory limitation. Statutory limitation is a deadline for starting a legal action or case. Different types of legal matters or cases have different time limits or have a different statutory limitation. An example of this is if you have an unfair dismissal claim, that's a claim relating to losing your job in a situation where you think it was unfair. That kind of matter has a 21-day time limit, a very strict and short time limit. If you wanted to bring a complaint for discrimination on the grounds of race, that kind of matter has a 1-year time limit. Whereas if you were injured and you wanted to make a claim for the personal injury that you experienced, you have 3 years to think about bringing a claim. So that's what the idea of statutory limitation is about. The last term on this slide is conflict of interest. This can come up where a solicitor has previously given advice or acted for another party in the same or a related matter, or where you and your solicitor have interests that clash. An example is a lawyer who previously advised a husband about his divorce. That same lawyer cannot act for the wife in the same family law matter or act for both an accused person and a victim in a criminal matter. There are 3 main areas where a lawyer might have a conflict of interest, and that is where the client's interests conflict with the lawyer's own interests, or where the interests of one of the lawyer's clients conflict with the interests of another one of the lawyer's clients, or where the interests of a current client conflict with the interests of a former client. So that's the concept of conflict of interest.
Okay, thanks, Bridget. So we've got some more legal words now.
Yes, so these are other terms that you may come across in interpreting in a legal setting. Burden of proof. The burden of proof is a legal standard that a person has to meet to prove their case. In civil matters, the burden of proof is called the balance of probabilities. And that's the next term on the list here. The balance of probabilities means more likely than not. And as I said, it's a standard of proof in civil cases, and it's also the standard of proof in apprehended violence order matters. So what that means is to win their case, a person has to bring enough evidence to prove on the balance of probabilities, or that it is more likely than not that what they say in their case is true. The next term is common law, and what that means is it's judge-made law. When a court decides a case, that court decision can make law. So decisions in the Supreme Court form part of the common law. The next term is statute law or legislation, and they are laws that are made by the Parliament of New South Wales or the Parliament of Australia. What can sometimes happen is that a court hearing a case makes a decision interpreting statute law or legislation, and their interpretation of that law then becomes a common law precedent. So you can see there's an interaction between judge-made law and laws made by the Parliament. The next term is duty of care. The duty of care is the duty that a person or an organisation has to look after another person. This is a legal duty. An example of this is an employer has a duty of care to make sure that the health and safety of their employees are looked after. There are laws about work health and safety. Or a doctor has a duty of care to make sure they give the best treatment possible to their patients. Procedural fairness. This is another legal concept. It's a legal principle that says that people must be made aware or told about claims or charges against them and be given a chance to defend a claim or charge made against them. Negligence is the next term. That is where a person has a legal duty of care, but they break it, and that causes another person to experience loss or damage. The next term is compensation, and the following one, damages. They are sometimes interchangeable terms. Compensation or damages is money claimed or awarded by a court to compensate a party for loss or injury. The idea behind it is to put that person back in the position they were in before a legal wrong happened to them. An example of this is if you were in a car accident and you claim damages in a court case after the car accident, those damages might include the costs of repairing the car, of hiring a replacement car, or replacing items that were in the car at the time you had the car accident. The last term on this page is terms of settlement. Terms of settlement are a document that records how two or more parties have agreed to settle a civil law case. And that's all for that slide, Kerry.
Great, thanks, Bridget. I've only had one question. Someone was asking about exceptions to confidentiality. So you talked about in the last slide the term confidentiality and what that means. Are there exceptions to that in law?
There are exceptions to that. Generally, if someone discloses to you what is a crime in a situation where you're obliged to report it, such as where the safety of a person is at stake. And there are some situations where protection of a child might be involved, and in that case, a solicitor may be obliged to disclose what their client told them. So there are some particular situations in which there is an exception to a solicitor's duty of confidentiality.
Okay, thank you. So Bridget, tell us, what is civil law?
Civil law can sometimes be a little bit hard for people to understand. If you talk about criminal law, most people understand what that is because usually the police are involved. If you talk about family law, people have a general idea about what that is because it involves relationships between husbands and wives and people, and also issues related to any children they might have. The way we describe civil law at Legal Aid is we call it everyday problems that have a legal side to them. Civil law is a very broad area of law, and it can include issues that people might have about their finances, about accidents, property, employment, also housing and mental health, which we will talk about in greater detail in this webinar today. Areas of civil law where Legal Aid New South Wales can provide services include government law, and that might be immigration law or social security law, issues to do with Centrelink. There's also discrimination and employment law, consumer law, which includes issues that people have, as I said, with their finances, such as credit, or if they owe money or someone owes them money, or they have trouble paying their mortgage. There's also mental health law and guardianship law. That is laws that protect adults who have mental health issues or disabilities. Legal Aid also has a coronial inquest unit where deaths that are reported to the state coroner, and there might need to be an inquiry. There's also a work and development order service, and that's a program for disadvantaged people that can help them pay off a fine they owe by undertaking unpaid work or courses or treatment programs. So that just gives you an idea of what civil law can include.
Yeah, and if people are interested, they could go on the Legal Aid New South Wales website, and there's a whole section on there about civil law. So there's details of what we cover and also all our specialist services, as Bridget's just outlined. So Bridget, where does civil law happen?
Okay, so this slide about civil law, people and places. We've focused today on the tribunal that I've mentioned previously, called the New South Wales Civil and Administrative Tribunal, because housing matters and guardianship matters are dealt with in that tribunal, and there is also the Mental Health Review Tribunal. So NCAT, which is the short term for the New South Wales Civil and Administrative Tribunal, is a state tribunal that deals with quite a broad range of matters, and as I said, includes disputes about housing. They can also deal with disputes about building works or guardianship matters, or administrative review of some government decisions. NCAT is divided into different sections, and each section specialises in hearing matters, different sorts of matters. One of the divisions in NCAT is called the Consumer and Commercial Division, and that is the division where NCAT hears cases about housing and also about consumer issues, so where money is owed or where you might have a dispute about a repair that hasn't been done properly. The Guardianship Division is the section of NCAT that hears cases about people with a decision-making disability who may need someone to be legally appointed to make decisions for them. There's different applications that can be made to this division of NCAT, such as to appoint a guardian to make personal or lifestyle decisions for someone who has decision-making disabilities, or to appoint a financial manager for someone who can't manage their own financial affairs, for consent to treatment by a doctor or a dentist. That division can also review an enduring power of attorney or review an enduring guardianship appointment. They can also approve a clinical trial so that people with a decision-making disability can take part in a clinical trial. Then lastly, the Mental Health Review Tribunal. That's a specialist tribunal that's created under a law called the Mental Health Act. This tribunal has a wide range of powers, and they hear cases about the treatment and care of people with a mental illness.
Okay, great. Thanks, Bridget. So now take us through who's who when you're in a tribunal.
Okay, so this is just to give you an understanding of terms that you will hear used for different people who might be in a tribunal. A landlord is a person who owns a property that could be a house or a flat or a building, and they let someone else use the property for a fee. And that is called renting or leasing the property to a tenant. So a tenant is a person who pays a fee to live in someone else's property or to run a business in someone else's property. The next term is applicant. An applicant is a word that means a person who starts a legal case in a tribunal. Applicant is used in civil law cases, and it's the name for a person on one side of a legal matter. Respondent refers to the person on the other side of a legal matter, and it could be a person or organisation who has a case taken against them in a tribunal. Then there's the term agent. So in New South Wales, an agent, or sometimes they're referred to as real estate agent, is a person who has a license to act for people buying and selling a property in New South Wales for a fee. They also act for landlords who want to rent out their property, and you may see them in the tribunal because if they're trying to, if the landlord wants a tenant to leave the property, if they want to terminate that person's rental agreement, then the agent will represent the landlord in the tribunal. Then the next terms, barrister, lawyer, and solicitor, they are different words for people who are legally qualified, who give people legal advice and speak for them in a court or a tribunal. Lawyer and solicitor are basically interchangeable terms. Barrister is someone who stands up in a court or tribunal and speaks on behalf of a client. Often a solicitor or lawyer will involve a barrister where a case is fairly complicated and it's going to be in a court or a tribunal. Advocate, you will also hear about advocates in housing and mental health matters in NCAT. An advocate is someone who may or may not be legally qualified, but they can act for a person in a housing case in NCAT and also in cases before the Mental Health Review Tribunal and in cases in the Guardianship Division of NCAT. In these areas of law, an advocate can give you advice and act for you, but they may not be legally qualified. And the last term here is member. That is the word used for the person in NCAT or a group of people in NCAT who make decisions about housing cases or guardianship cases or in cases before the Mental Health Review Tribunal.
Okay,
That's
great.
all there. Yep. Thanks,
Covered
Kerry.
all of those. Thank you. So there's a few words coming up now, Bridget, about tribunals to go through before Olivia joins us.
I think Olivia was going to do this slide. Is that right, Olivia? Or
No,
not?
Olivia's doing the next one about housing
Okay.
documents.
Sorry about that confusion.
That's
Okay.
all right.
Mention. This is a word that you might hear used in courts or tribunals. A mention is a short appearance in a court or tribunal where no major decisions are made. So at a mention, a member in a tribunal won't make a final decision about a matter, but it's a way to get the parties before the tribunal so that the tribunal can find out how preparation of the matter is going by the parties. And at a mention, one of the parties may ask for what's called an adjournment for, which I'll explain a bit further, but they may ask for extra time to prepare their case. And at a mention, a court or tribunal can also give a date for when the matter will be heard, which is the final date when the parties have to present their evidence and any witnesses they have, and then the court or tribunal makes a final decision. Call over often happens once a matter has been set down for hearing. So when the court or tribunal has given a date for when they will hear all the evidence, and at a call over, they can check that the parties are going to be ready for the hearing. A call over is another part of the way that courts and tribunals manage the cases that they have before them. Hearing that's when the parties present their evidence to the court or tribunal, and the member in the tribunal hears the evidence, and both parties get to ask questions of any witnesses, and then the member will make a decision about who wins the case. Ex parte, that's a term that you may hear, and ex parte is when the case goes ahead and the court or tribunal makes a decision, even though one of the parties is not there. The member or magistrate in a court have to make a separate decision about whether they will hear a case ex parte or in the absence of one of the parties. It's a very serious issue because both parties have a right to be there when the matter is heard and present their evidence, but sometimes there isn't a good reason for someone not to be there, and the tribunal may decide to go ahead and hear the evidence and make a decision in the absence of that person. Interim hearing. Interim hearing is a hearing that looks at issues that need to be decided in the short term. These might be urgent issues such as ordering that a payment may be made, but it's not the full hearing of all the evidence in a matter. Interim order is similar to an interim hearing in that it's an order made by a court or tribunal for the short term. So it's an order, it's not a final decision, but it usually helps one of the parties or both parties maintain the current situation until a final decision is made. Conciliation. Conciliation is an informal meeting where parties try to resolve the dispute between them before the case is listed for a formal hearing. It gives parties an opportunity to resolve the dispute without the member having to hear all the evidence and make a decision. Adjournment, that's what I mentioned earlier. That's when there's a postponement of a tribunal appearance or hearing to a later date. It's usual to ask for an adjournment at the beginning of a case or early on. It might happen if you're waiting on a report from a specialist for your case and the specialist is taking too long, and so you have to ask the court or tribunal for more time so you can have that report to use as evidence. Stay of proceedings, or the word stay. This is when an order of the tribunal is made that stops a case from continuing, either permanently or temporarily. A stay order might also be made that puts a tribunal case on hold because there's a related court case that's being heard. Sometimes cases in the tribunal might have related criminal matters in the local court, and so a party might ask that the tribunal doesn't hear its case until after the criminal case has been decided. So the tribunal might order that the case before it is stayed or put on hold until after the other case has been finalised. Evidence is information. It can be either documents or people giving evidence, witnesses giving evidence in court, and it's used in court to prove something. There are strict rules in civil matters about what evidence can be used and how it can be used. and this ensures fairness between both parties. Set-aside application. So a set-aside application might be made after a tribunal has decided a case ex parte or in the absence of one of the parties. It's an application to set aside the orders made by the tribunal or to vary a decision made by the tribunal. It might happen if both parties agree, or if you missed out on your hearing and you apply to the tribunal and you have a very good reason why you weren't there, why you couldn't attend the hearing, then the tribunal might agree to set aside the orders it made or the decision it made so that you have a chance to put your case to it. And then the last term is appeal. So in NCAT, in the New South Wales Civil and Administrative Tribunal, you can appeal a decision of a member of the tribunal to what's called an internal appeal panel. So if you appeal that decision, you're asking that the decision of the member be changed or cancelled. In NCAT, you can only appeal on a question of law, which means if you think the member applied the law incorrectly in your matter. You can sometimes appeal on what's called the merit of the decision, but only with leave of the appeal panel. This means you're appealing because you think the tribunal should have been persuaded by your evidence and decided the case in your favour instead of in favour of the other party. That's a decision on the merit.
Great, thanks, Bridget. Someone's asked if you could just explain the difference between mention and call over again. They said they sounded the same.
Well, they do sound the same, and they can be interchangeable terms, and sometimes a court or tribunal might tend to use one of those terms over another. They are very similar. They're just an opportunity for a court or tribunal to bring the parties in a case before them to find out how preparation of the matter is going and if the parties are going to be ready for a hearing date that may have been set, or it's a way for the court or tribunal to bring the parties before it so they can set a date for when the matter will be heard. I don't really think there's any difference. They're just different terms that mean the same thing.
And another question is, does a person have a choice of whether their matter is heard in a tribunal or not, or does it depend on the type of case?
That's a good question. It depends on the type of case. So there's another term that I haven't mentioned, which is called jurisdiction. So what that means is that courts and tribunals are given the power to hear different sorts of cases and also for different amounts of money. And so if a court or tribunal has jurisdiction to hear a particular case, then you need to bring that case before that court or tribunal. So NCAT has jurisdiction to hear cases about housing and tenancy and about consumer complaints, and also about issues to do with guardianship, whereas the local court has jurisdiction to hear criminal cases and also cases about involving money. And sometimes you might have a choice to go to either a court or a tribunal, and you might make that decision after you get legal advice, because a tribunal is often a place that is less formal than a court and easier for people to act for themselves in, whereas a court can be a bit more formal. It might also depend on the amount of money that is involved in your matter.
Okay, thank you. So we're going to bring Olivia into our webinar now. So Olivia, one of the questions we just had, if you don't mind, I might just get you to talk about that, is they were asking who can be an advocate? Can it be a family member? Can it be a support worker? Or is it need to be someone who's registered with the tribunal to be an advocate? How does that work?
So advocate's a very, very broad meaning term. It doesn't necessarily have to be someone who's legally trained or gives legal advice. So I'll go into a bit later. There's a concept called a tenants advocate, and a tenants advocate is someone who is normally appointed in a role working normally in a legal centre who does have legal training and can give tenants advice. But family members can also act as advocates sometimes, especially in housing matters. Tenants can sometimes get very emotional and they can find that they don't feel like they'll be able to speak in the tribunal or explain their matter, clearly about what's going on without breaking down or getting very emotional. So sometimes they'll ask for a family member to have permission to speak on their behalf to give kind of a better example of what's going on. That person can act as an advocate or a friend or a family member. They do have to ask. Bridget did mention before about asking for leave from the tribunal. So leave to appeal or leave to have an advocate. That basically means permission. So if you do want to have an advocate representing you in the tribunal, you have to ask the permission of the tribunal to allow that. And then the tribunal will decide whether this person is going to help the matter, if they know enough about the matter to be informed, things like that before they give you permission to have that advocate represent you at the tribunal.
Great, thank you. Well, this slide's now come up. Words about housing documents. Do you want to take us through those?
Absolutely. So first off the block, statutory declaration. Good start. This is a written statement declaring what is going to be or what is the truth. So a statutory declaration is written. It's the factual evidence that a person who's making the statement. It has to be affirmed or sworn in front of an authorised person. This can be a solicitor sometimes or a justice of the peace. And if a person lies in a statutory declaration or says something that is not true, then they can be charged with a criminal offence. A statutory declaration is used very, very often in everyday life. So a lot of people listening into this seminar have probably done a statutory declaration at some point in their life. It's often used to get documents like passports, licenses, birth certificates, marriage declarations, all kinds of documents will generally require some form of a statutory declaration to be made. In that, when I said that a statutory declaration has to be affirmed or sworn, that leads into what the next concept is, which is an oath or an affirmation. So often, as Bridget was explaining in the tribunal, sometimes if you're being asked to give evidence to the tribunal, the member will ask you whether you want to make an oath or an affirmation before you give that evidence. That is essentially a promise that you make to the tribunal to say that the evidence you're giving will be the truth. The difference between an oath and an affirmation, and most people when they get asked, do you want to make an oath or an affirmation, most people say, I don't know, what should I make? The difference with them is basically an oath is religious and an affirmation is non-religious. So if someone's making an oath, they'll be swearing on a book of their religion, such as the Bible or the Quran, whereas an affirmation is non-religious and it's simply a solemn promise to say the truth. And you have to do this in front of an authorised person. So at the tribunal, it will be in front of the member. The next word is an application. So an application is simply the form that you fill in when you want to begin proceedings at the tribunal. It's a fairly standard form and it simply tells the tribunal and tells the other party what the crux of what you're asking to be done or what decision you want to be made is. It puts the other party on notice about what the matter's about, what they're going to the tribunal to discuss. Okay. It also asks you what decision you want to be made. It also asks you who the parties are to the dispute. So it can be fairly procedural, just filling in people's phone numbers, addresses to make sure that anyone who should be informed about those proceedings at the tribunal are given notice and are able to attend if they want to attend. A summons is a document that's used in the tribunal to tell someone to come to a hearing or to send documents to that hearing. So most commonly in the tribunal, in my experience, a summons is generally used for the police. So if there's an allegation that there's been something illegal going on at the house, that there's been illegal drug selling at the house, for example, a landlord may ask for a summons to be issued to get the police to provide evidence to the tribunal that might be relevant to the dispute that they otherwise wouldn't have access to. A notice of hearing is simply a letter that you get in the mail or by email telling you that a hearing is going on, where and when. At the tribunal, a notice of hearing will also come with a copy of the application so that you get a copy of the application that says what it's about, what decision the other party wants to be made. A notice of order comes at the end, and this is a letter telling the parties about an order that was made at the tribunal, and that's essentially what decision was made by the tribunal. So generally a notice of order will just be confirming what was told to you on the day, what you might have heard in the tribunal hearing if you were there in person or over the phone. If you weren't at the hearing, so if you missed your hearing and a decision was made in your absence, a notice of order will explain the decision that was made.
Okay, thanks, Olivia. So now we're moving on to some housing law words to take us through.
Housing law. So this is quite a detailed list of all of the words. I'm just looking at the time and I might have to go quickly through. Bridget's amazingly already explained what some of these words are. So I may just gloss over some of them, so I apologize. But we can just start with the parties. So the parties to the dispute are generally interested people to the dispute. So in housing, it's generally the landlord and the tenant. So the landlord is the owner of the property. It can be an individual person, a corporation, a charity. It can also be what we call a social housing provider. A social housing provider is, for most social housing, it's the government providing housing. It can also include what we call community housing providers. So those are individual corporations who assist the government or are contracted out by the government to provide housing to vulnerable tenants who meet certain eligibility to be living in that housing. Tenants are people that rent the property. They have responsibilities to look after the property, to pay their rent, to keep it clean, but they also have a lot of rights. So the right to privacy, security, safety, and comfort in their house. A subtenant and a head tenant, that's where the owner of a property might lease or rent out that house to one person, the tenant. And if that tenant then rents out, say, a room in their house, or they may rent out the granny flat to another person under a separate agreement. Where there is that I guess two separate tenancies, the subtenant and the head tenant are different relationships. There can also be what we call an additional occupant. This can be very confusing for a lot of people to understand what an occupant is. Essentially, an additional occupant is someone who lives at the house but isn't written on the lease as the main tenant. So that might be another family member who lives at the house and the real estate agent knows that they live there and give permission for them to live there, but they aren't named as a tenant, and so they don't have the same legal rights and obligations as a tenant. I've already explained, so an agent manages a property. That's the easiest way to explain it. So they don't own the property, the landlord owns the property, but landlords will often hire a real estate agent to manage the day-to-day dealings of a rental property. A tenant's advocate, that's someone with specialized housing knowledge. They often have legal training, although they may not be a lawyer, but they have specialist training that's recognized by the tribunal, and they get special leave to assist tenants to give them advice. The easiest way to think about a tenant's advocate is specialized assistants who can balance out the power between a landlord and an agent and a tenant on the other side. So if we go into the, these are a couple of terms that just go to the base of an agreement. So when you're talking about a rental agreement, the easiest way to generally express a rental agreement is through a lease, and that's a written document that says all of the terms and the conditions upon which you're going to live at a house. So a lot of you have probably signed a lease in your life. It sets out the rent that will be payable, the obligations, who to call if something goes wrong. It also will normally give you your landlord's name and details on there. If a tenancy is expressed in that way, so there's a written lease that sets out that you're going to live at this house from the 1st of January of this year until the 31st of December of this year, that is called a fixed term tenancy. So often at the tribunal, we will talk about two different types of tenancies or two different types of tenants. The first is a fixed term tenancy where you have agreed to live at a property for a specified period of time and we're still in that period. If that lease has expired, so you've stayed on for a couple of years and you just haven't signed a new document, or if you never signed a document and you just moved in on a verbal agreement, we call that a periodic tenancy. A periodic tenancy is often called a month-to-month or a week-to-week lease, and it's where you live there, but you don't have that written agreement still. And also, Kerry, just pause me if there's any questions. I'm happy to.
Yeah, no
field.
questions so far. It's all going well. Thank you.
Oh, that's okay. All right, so the next term that you'll often see in an agreement underneath what the rent is going to be is the bond. A bond is 4 weeks of your rent, generally. It maxes out at 4 weeks of your rent. So what a bond is a payment that you make to the body called Fair Trading. You lodge a bond with Fair Trading and they hold that bond as security in case anything goes wrong during your tenancy. So you'll often hear about bond disputes when people have moved out. A tenant will try and claim the bond back, and a real estate agent or a landlord might try and say that they want part of the bond or that they want all of the bond because the tenant owes them money for things like rent, for electricity bills, or if there's been damage to the house. So a bond is generally used to cover those payments. And importantly, it's the tenant's money until the landlord proves that they can have a legitimate claim to those monies. So if a landlord wants to claim the bond, they have to prove why they should be able to claim that bond. Going into the next couple of words, are all to do with rent. So they're all to do with the money that you exchange in terms of living at the property. So market rent is a term that we will often use to describe the basic rent that anyone in the tenancy market or in the housing market would pay to live at that house. So it might be $400 a week, say. It's just the normal rent that a tenant will pay to live there. If something goes wrong at the property, a tenant might be entitled to or might ask for a rent reduction. So rent reduction is where for a specified period, there is a reduction in rent to allow or to, I guess, compensate a tenant for something that's gone wrong at the house. This might be in an example where a shower is broken and so the tenant can't use the main shower while it's getting fixed for a couple of weeks. A landlord may agree to reduce their rent, say by $50 or $100 until that shower is fixed to make up for the fact that that tenant has been inconvenienced. Another term that is often used is rent deferral. Now, this is not a legal term. It's not used anywhere in the legislation, but a rent deferral has been used or talked about a lot in the last 18 months during COVID. And agents often use it to say that they are letting a tenant delay paying their rent, or a tenant might ask to delay paying their rent. So that may be in a situation where a tenant has lost job or lost a couple of weeks of work, say to lockdowns. They may ask for a rent deferral to say, I can't pay my rent this week, but I'll pay double my rent next week to make up for it. So a rent deferral, it's not a legal term, but it essentially means that you're asking to be allowed to delay your normal rent payment for some time with an agreement that you'll pay it back later. And that's the difference between a rent reduction and a rent deferral, is with a rent reduction, you don't have to pay it back at a later date, whereas with a rent deferral, you do pay that back at a later date. A subsidy is an amount, it's generally used in social housing, so that's where I was talking about where the government helps to provide housing. And a rent subsidy essentially is where a tenant will pay a portion of their income towards the rent instead of paying the full market rent. So in most government housing, the way that they calculate the rent is at 25% of what a person earns. So instead of saying that that person has to pay $400 a week in rent, that person might only have to pay $100 a week in rent, as long as they prove to the government or prove to the social housing provider that they are still entitled to be getting that subsidy. So often they have to be providing their income details like you would with Centrelink, providing your income details and asking to continue to get that subsidy. A ledger is the next word. A ledger is basically a record of the rent that is paid. It's normally kept in one document by the landlord. If a tenant is, if they ever pay rent but it doesn't make up a full week of rent, so they may just make an odd payment of $75, often that will show up on a ledger as the next term, which is cash in hand. So cash in hand, you'll hear agents say it a lot at the tribunal. I didn't know what this meant when I started doing this work, and a lot of tenants don't know what it means. Cash in hand is just when tenant has paid money, but it's not enough for a full week of rent. So up until it's a full week of rent, they keep it on the ledger as called cash in hand. Arrears is when a tenant is behind in rent. So if they've missed rent for a couple of weeks and they haven't been able to make it up yet, that is called arrears, and that's the amount of money that is owing. Rent in advance is the alternate. That's where a tenant is paid ahead of time. So a lot of tenants will try and keep their rent a couple of weeks in advance so that if there's ever problems, they know that they're still paid up to date. And it is a legal obligation generally for a tenant to be 2 weeks ahead in rent. An occupation fee, this is another word that confuses a lot of people. An occupation fee applies after the tenancy has been terminated by the tribunal. So where the tribunal has said that the tenancy is going to end, but they've allowed the tenant to stay there for a couple of extra weeks or a couple of extra days to pack up their goods and to leave, the tenant has to pay an occupation fee. The reason that they call it an occupation fee is because once a tenancy has been terminated by the tribunal, the tenant can leave at any time and just pay rent for the days that they're there. So instead of calculating rent on a weekly basis, it's calculated on a daily basis, and they call it an occupation fee.
Great, thanks Olivia. Someone's asked about notice periods for fixed term and periodic tenancies. Is that on your next slide, notice periods?
We go into termination notices, so I can
just quickly just say what are the notice periods for if someone's on a fixed term or a periodic.
So essentially to give a very quick explanation, for a lot of notices, they will be the same no matter what type of agreement you're on. For example, if you fall behind in your rent and the landlord is giving you a notice of termination for rent arrears, whether or not you're a periodic tenant or a fixed term tenant, the notice period is the same. It's 14 days notice. The only time when it's different is if the landlord is not alleging that you've done anything wrong, then the notice to get you to leave is different. So in a fixed term period or a fixed term lease, if you're not doing anything wrong, you're paying your rent, you're looking after the house and everything's okay, but the landlord wants you to leave, at the end of your lease, they have to give you 30 days notice, and that can expire on the last day of your lease. If you don't have that week to week or you don't have that fixed term lease, and you're in a periodic tenancy, if you're not doing anything wrong and the landlord just wants you to leave, they have to give you 90 days notice, and that's called a no grounds notice. So yeah, if you do something wrong in your tenancy, it's basically the same across the board, but if you are fine and they simply ask you to leave, it's 30 days notice in a fixed term tenancy and 90 days notice in a periodic tenancy.
Okay, thank you. So you want to take us through these words? I'll just let everyone know that we'll probably, be about 5 or 10 minutes before we start on our mental health words. So this webinar may go over time about 15 minutes, but we'll see how we go towards the end. So yeah, take us through these, Olivia.
All right, so I might just skip to notice of termination since we just briefly touched on it. A notice of termination is a request to end the tenancy. It can be made by either party, by the tenant or by the landlord. It has to be in writing to be a valid notice of termination. That is a very specific legal word, and it has to be in writing and take a specific form. But essentially, that is where one of the parties wants the lease to end for some reason, and it will set out that reason in the notice of termination. So as I said before, it might be because your lease is just coming to an end. It might be because you've done something wrong. It might be because the landlord's selling the house and needs to vacate the tenants before they can sell the house. It can also happen where the landlord has done something wrong. So in the example before where the shower's broken, say that landlord just never ever fixes the shower, the tenant might say, well, I can't continue to live here, and give a notice of termination that if the landlord doesn't fix the house, then they will be leaving. It's important to know that the notice of termination doesn't end the tenancy itself. It's just a request, and it's up to the parties whether they want to leave in accordance with that request or whether they want to stay and fight it. And if they want to stay and fight it, that's when the matter will go to the tribunal. And just hopping back to a strike notice, it's only used in social housing, so it's not used by private landlords and tenants, but it can be used in social housing where we've discussed things like a subsidy and there's certain eligibility to live in the house. Social housing also has the power a landlord has the power to issue a strike notice. A strike notice is basically a warning that the tenant has done something wrong. So it may be that they were playing their music too late in the middle of the night and were disturbing the other neighbours, but it's essentially a warning to fix their behaviour. And if they get 3 strike notices, the 3rd strike notice can come with a notice of termination. So this is often used where the bad behaviour isn't enough for the landlord to want to end the tenancy right away. But if that behaviour continues on and on, it may get to the point that the landlord asks the tenant to leave. Now, jumping forward to discretionary versus mandatory provisions. So these two words, discretionary and mandatory, are often used when we're talking about termination notices, because some termination notices you can fight on the basis that you don't think it's correct that you're being asked to leave. So for example, if you're being asked to leave because you're playing your music too late at night, say, that is a discretionary provision. So that means that the tribunal has the power to decide whether or not you playing music in the middle of the night is enough to then justify terminating your tenancy and forcing you to leave. So the tribunal has the power, if it gets to that point, the tribunal has the power to save the tenancy if they want to. With a mandatory provision, that means that at the tribunal, if it gets to that point, and the tribunal satisfied that the landlord has completed all of the paperwork, say, in the right order and they've applied to the tribunal and they've followed the correct process. A mandatory provision means that the tribunal member has to terminate the tenancy. So there's only 2 mandatory termination notices, and those are the ones that are discussed in the question. It's where a lease is coming to the end, or it's where there was no lease, but the landlord has given that 90-day no grounds notice. For those 2 types of notices, if the landlord has followed the procedure right, has applied to the tribunal, has done all of their paperwork in order, then the tribunal has to terminate the tenancy. And the only power that the tribunal has is to say whether the tenant has to leave now or whether they can have a couple of weeks before they have to leave. Where the tribunal has made that decision to terminate a tenancy, they have to make what we call an order for possession. So that will say what day the tenant has to leave the property. So as I said, that doesn't have to be on the day that the decision is made. The tribunal might hear a matter today and they may say the tenancy is terminated today, but the order of possession is suspended for 4 weeks. That means that the tenancy is terminated, but the tenant has 4 weeks to leave the house, to pack up their goods, to clean, to do all of that kind of thing. If the tenant doesn't get out by that date, when the order of possession is, then the landlord can ask for a warrant for possession. And that means that they can ask the sheriff, who's a legal officer, to go to the house to enforce the order, to remove the tenant and to change the keys or to change the locks at the house. After a tenancy's ended, there's 2 main things that, or other than bond, there's 2 main things that people want to talk about, and they want to know whether or not the real estate agent is going to give them a good or a bad reference. That's not something that unfortunately we have a lot of control over, but a bad reference is essentially where something's gone wrong at the property and the real estate agent doesn't recommend that tenant to another landlord. A tenancy database is a bit more, or not a bit more, it is a lot more official than a bad reference. A bad reference is normally just a phone call by an agent to say that they wouldn't recommend a tenant for another property. A tenancy database listing is where a real estate agent has put that tenant's details onto a database where it says that basically they have done something very wrong in their tenancy. There's a few reasons why a tenant can be listed on a database, but it's generally where you have left owing more than your bond and you haven't made an agreement to repay those monies, or it's where you were evicted because you did something wrong and the sheriff had to remove you from the property. So in those situations, a landlord may put you on a blacklist or list you on a tenancy database, and that listing can stay up for a period of 3 years, although you can appeal it and ask to be removed from that listing for certain reasons.
And our lawyers help people with that, don't they, Olivia?
Absolutely, especially in my role, a tenancy database listing, a lot of people don't know that they've been listed on those lists, but it can be the reason why someone's putting in, 200 rental applications and they're not even getting a call back. Often we discover that they've been listed on a blacklist, and often the landlord or the real estate agent hasn't done it properly, and we can often help to get them removed.
Great. Well, that's fantastic. Thank you so much, Olivia. I haven't got any other questions about housing law words. You've obviously done an amazing job explaining these words. And I will remind everyone that there are those handouts on the control panel for your GoToWebinar, which includes these words that both Bridget and Olivia have covered, explaining them in detail. So you do have that as a resource, and they were emailed out this morning as well. And we're just going to be joined by our next 2 speakers, Penny and Joe. Just checking you can hear me, Penny?
I can, yeah.
And we can hear you. Great. Here's Bridget again. We're just waiting for Joe to join
Beautiful.
us. Hopefully she can come. But Penny, you're going to start anyway, aren't you? So do you want to start by taking us through these words that have come up on the slide, civil mental health words? Here's Joe. Hi, Joe.
Yes.
So Penny's going to start us off.
Okay. Hi, everyone. I'm Penny Adams. Please feel free to jump in and ask questions. I had a lot of words on my list, a lot of them being medical terms. I'm not a doctor, so there's a limit to which I can really go into detail to explain medical words, but there are a lot of medical words that come up in this area. So what I thought I'd do is explain the legal terms in a bit more detail. And then if anyone has any questions about the medical terms, I'm happy to do my best to help. And also, if at the end of this session, you've got questions that arise while you're working, or you just think of something, please feel free to email me. I think Bridget was going to send through my contact details. So yeah, happy to answer questions. Anyway, so in terms of the legal words, so I'm just talking right now about words that come up in the civil mental health area. So that's where, you know, a person is experiencing some mental health problems and they get taken to a hospital, or they go to a hospital and they get assessed by, well, eventually a psychiatrist. But essentially what happens is that, first of all, a person might be brought to a hospital and they're assessed at emergency. The person who assesses them should be someone called an authorised medical officer. It doesn't have to be a psychiatrist at that point, but it has to be someone authorised. And that person can decide that they think that the person needs to be detained. So needs to be admitted to the hospital whether they like it or not, okay? At that point, if a person is admitted to a hospital for further assessment, that we refer to them as an accessible person. Now that's just a bit of a legal jargon word, because most people in the community at the point where someone's detained would just consider them to be involuntary. So, but legally there is a difference between an accessible person, who is someone who is yet to be brought to the tribunal for a mental health inquiry, and someone who's already had their first mental health hearing, their first hearing before the Mental Health Review Tribunal. That's when they become formally, legally, an involuntary patient. So, so a person's detained, they have to be assessed by a couple of different people. The first one tends to be the authorised medical officer, and then they're assessed by a psychiatrist. Now, they have to be brought before the tribunal for a hearing, which is the first hearing, the mental health inquiry. I think what I'll do, sorry, I'm just going to move my document out of my way so I can see the slide a bit, but I'm working with two documents here. Okay, so we've got accessible person, involuntary patient. So you can see the next two words on the screen are the involuntary patient order and the mental health inquiry. So the purpose of the mental health inquiry is for the tribunal to decide whether or not to make an involuntary patient order. And that's where the person becomes an involuntary patient, if that involuntary patient order is made. Now, the thing that I try to explain to patients, the advice that we need to give them about that involuntary patient order that you will find yourselves interpreting, is that the order gives the hospital permission to continue to detain the person and treat them in the hospital for a maximum period of time. So usually it's somewhere between 4 to 12 weeks. For the initial inquiry, it can be pretty much any time, okay? But the usual time is kind of 2, 4, 6, 8, 12 weeks. But that is a maximum period of time. At the end of that time is just a review by the tribunal. So the person's brought back to the tribunal. That's only if they're still in hospital, because the hospital has an obligation, a positive legal obligation to discharge the person as soon as there's a less restrictive way of treating them safely and effectively. So usually the only options for less restrictive treatment are either discharge back home, they go back to the community, or discharge on a community treatment order. Now, community treatment orders actually are not on the list. But essentially it's where a person must comply with certain conditions around engagement with the community mental health team. So it's a bit like being treated, but as an outpatient through the community health team, okay? And if they don't fulfill those conditions, if they don't take their medication, if they don't see their case manager or their psychiatrist, then they can be taken back to hospital and detained again for assessment. So that's considered to be a step-down option, a less restrictive option than being detained in hospital. Now, as soon as the hospital thinks that person is ready for something like that or just discharge, they have to discharge them. They don't have to ask the tribunal first. The only thing they have to ask the tribunal is if they want to detain them for longer than the current term of the current involuntary patient order. So I always try to explain very clearly to patients, because they get really hung up on how long is the order? How long is the order? Because they think that the end date of the order is their discharge date, but that is not the case. They could be discharged, they could get an involuntary patient order for 4 weeks, they could be discharged tomorrow, they could be discharged next week. So that can be quite confusing for them, but it's important for them to understand that. So that's an important thing to note about involuntary patient order, is the end date is not the discharge date. And it goes the other way. If the person is coming up to the end of their involuntary patient order and the hospital still thinks they need further treatment in the hospital, then it goes back to the tribunal, another application is made for another IPO, involuntary patient order, and the tribunal considers that and then can make another order. That's what happens at a mental health review, which is the next term on the list. So so I think that's one of the most important things for people to have their heads around, that it's not, that the period of time for that IPO is actually not really that important. What's important is how the person is actually progressing with their recovery. Okay, so the mental health review, exactly the same as an inquiry. I do like to explain, I usually ask people, have you ever been to a hearing before the tribunal before? I try to explain to them that the purpose of these hearings is so that the tribunal, which is independent of the hospital, it's a totally separate entity that was set up with the purpose of checking up on the hospital. So making sure that the hospital is doing the right thing when it's detaining this person against their will, because obviously that's a really significant thing to do to someone. And so the purpose of the tribunal is to oversee that decision, to check that that decision is happening according to the law. On the tribunal, there are 3 members. There's the legal member. People often think it's a judge or a magistrate. It's not. Sometimes they have ex-judges and ex-magistrates, but that's not their role at that time. They're just a lawyer. Then there's a psychiatrist. For reviews, so it's a bit different. With a mental health inquiry, there's just a lawyer, one person. with a review, it's the 3 people. So it's the lawyer, the psychiatrist, and the suitably qualified member of the community. So usually just a person who's got some experience in mental health, in the mental health area. Often they're social workers, sometimes they're psychologists. Yeah, so the only other real difference at a review is that the kind of default position, the policy, if you like, it's not in the law, but the policy of the tribunal is that that if an involuntary patient order is made again and there's to be another review, they usually just set that period for 3 months. And that's mainly because, you know, they don't want to have people coming back to the tribunal constantly. If you've been in the hospital for that long, then who's to say how much longer you'll need? They prefer to make it 3 months, but we can argue that, you know, that the tribunal should give it a shorter time for a number of reasons. Sometimes we just get the feeling that the patient is really struggling with the admission, with being detained, and they just needs a little bit of hope. It's really, sometimes it's just, you know, it's just a matter of asking the tribunal to take into account the distress that the detention is causing the person and to give them an earlier review date. Sometimes it's because we want to put a bit more pressure on the treating team if we feel like they really should be working on a discharge plan. So yeah, there are a few different reasons, but generally, yeah, the next review would be 3 months unless there's a good reason. So then we're looking at the admission documentation. So as I said, at the point where the person's being detained, there are some forms that need to be filled out. Usually there's the schedule, which is the document that actually gets the person to the hospital, gets them admitted to the hospital. Then there's the first form 1, which is the form that the authorised medical officer who does the first assessment of the patient needs to sign. Often that's the psychiatry registrar, but it could just be the doctor in ED. Then there's the second form 1, and that's to be signed by a psychiatrist. Now, these things are discussed a little bit at the mental health inquiry, because the first thing we need to check is that the proper process has been followed for a person to be detained legally. So it's pretty important that these documents are done. The first form 1 should be done within 12 hours of the person having been admitted. And the second form 1, the psychiatrist should see that person within a reasonable period of time. Now, what's reasonable really varies. You know, my rule of thumb is to raise it. If it's more than about 5 days, then I'd make a point of asking why it's taken so long, just to, you know, because I think that that's a real issue if people are waiting for a long time to see a psychiatrist when they're being detained against their will. They'll also ask the patient if they've been given a copy of their statement of rights. That's a double-sided piece of paper. The patient often won't remember getting it, but the hospital should actually get a signed document where the patients acknowledge that they've received it. But often on admission, the patient's so unwell that, you know, they'll refuse to sign that because they don't want to sign anything, or they're either unwell or they're really distressed. So there can be a bit of, sometimes it needs to be explained to the person what the statement of rights is. So it's just that document. We just usually tell the patient it's like a double-sided piece of paper that tells you what your rights are. And yeah, we try and work out whether they've received a copy, and if not, the tribunal will usually just ask for them to be provided with one.
Someone's made a note here, Penny, that
yes.
often that statement is always in English. Is that right? Or is it available in other languages?
It should be it is available in other languages. So yeah, it should be, people should be able to ask for one in their language. I think, Joe, can they download a different language one off? They must be able to download one and print one if they don't have one already printed. Do you know what the process is?
Can you hear me?
Yes.
Yes.
Yeah.
I must say,
Sorry to put
I
you on the
have,
spot there. I'm just not
Yeah.
sure what that process is.
it's been, I mean, in the past, I have downloaded statement of rights in various languages, but I can't like recall off the top of my head where to get it, but I can look
Yeah.
into that. But I have
Yeah,
downloaded
that's
that
okay.
myself.
Okay, I wanted to make sure I'm telling the truth. Yeah.
Yes,
But
you are.
yeah, so yes, it is available in other languages, and it should absolutely be made available by the hospital to the patient in their language. So if you're assisting a patient at a hospital, and all you've got in front of you is a copy in English, then definitely ask if they can please download and print a copy in the as long as one's available in the language. But yeah, they should be available.
And
Are
Penny,
there any other questions about?
there's no other questions,
Yeah.
but one of the words on that slide that we didn't talk about is mentally ill person. Is that a term?
Oh, mental
that
person. Sorry,
interpret-
did I skip that
Yes.
one?
It's all
Oh
right.
yeah, mental ill person at the bottom there. Yes, sorry about that. I was on a roll. Yes, mental ill person. So that's kind of like the key concept. So excellent that I left that out. So when the assessments are being done of the person, when the person comes into hospital, and when the tribunal reviews the person or conducts the inquiry, the question is this person a mentally ill person? Now, just because someone has a diagnosis, let's say, of schizophrenia, that doesn't make them a mentally ill person. A mentally ill person is a strict, in this context, is a legal concept. It's defined in the Act. And the way that I explain it to people is there's kind of two parts to it. The first part is whether the person is suffering from particular symptoms which are listed in the Act. So you'll find some of these, or hopefully all of them, words in the list of medical words. So in the Act, the person has to be suffering from delusions, hallucinations, a serious disorder of thought form, a serious disturbance of mood, or they have to be exhibiting behavior, I can't remember the term, but unusual or bizarre behavior that indicates the presence of one or more of those symptoms. So it's not about diagnosis at that stage. Some people won't have a diagnosis when they come into hospital, and that's something to be worked out by the treating team. Yeah, so it's about how the person is presenting and whether any of these particular things are actually present. And I think it's really significant that it's a serious disorder of thought form or a serious disturbance of mood, because it's not enough that the person exhibits just a bit of thought disorder, right? So there've been times when I've had to kind of press the treating team, because they're saying, well, there's something going on here, but it's not really severe, and to justify detaining someone, it has to be pretty significant. So that's the first part of it, is that the person is exhibiting the kinds of symptoms or behaviours that are actually listed in the Act. And then the second part of it is, just the fact that that person's experiencing those things create a risk of harm to them or other people. And importantly, the first thing that I am very quick to tell people is it doesn't have to be physical harm, because most people think, oh, well, they think I'm going to go out and stab someone, right? I'd never do something like that. So it's not about physical harm necessarily. There are all different kinds of risks of all different kinds of harm that the person could be at risk of experiencing or inflicting. So things like harm to their reputation, if they're communicating with people in a disordered way, if they're suffering from delusions, that kind of thing. they could there could be a risk of harm to their relationships, harm, financial harm. You know, if they're really elevated in mood, you know, what colloquially people would refer to as kind of being manic. You know, they might spend a lot of money, that kind of thing. Or another common one is risk of misadventure, which basically is risk of making decisions that might put that person at risk, you know, like just making bad decisions, you know, being indecent at the bus stop or walking into traffic, or, you know, like just problems with decision making that might get them into trouble one way or another. So yeah, so that these are the kinds of harm. It has to be, you know, serious harm. It can't just be something relatively trivial again. So those are the kind of two parts of it. Are they exhibiting signs of significant mental illness? Is there a reason to think that they could cause serious harm to someone or themselves? And then I guess the last kind of which comes, it's not so much in the definition of a mentally ill person, but to justify detaining that mentally ill person, there really needs to be that element of, is detention in a hospital the least restrictive, you know, way of safely and effectively treating this person? So that's the other thing the tribunal has to consider when it's looking at detaining a mentally ill person. So thanks for pointing that out. Can't believe I missed that one. Any questions about that one?
There's no questions. And the next slide we're bringing up is just all those health words. So they're on the handout that we've given people with definitions. So we might move on given the time. So people do have those words and the definitions in the handouts, which are on your control panel, and I emailed them out this morning, and I also included in that email Penny's email address if you've got any questions. So what we'll do is we'll move on to forensic mental words, and that's where you come in, Joe. So you're going to take us through the definitions of these words on the slide now.
Yes, you can hear me. Yes. So I'm going to take you through the forensic mental health words. So you've just heard Penny talk about the civil mental health regime. So forensic mental health is a lot more, as you can see, there's a lot more just like legal words. So basically it's people who were unwell, mentally unwell, or have cognitive impairment, and they have committed certain offenses. And then what happened is they would become, and they become a forensic patient. Say the Mental Health Review Tribunal review them. The difference is that the Mental Health Review Tribunal reviews them every 6 months, and the basis, the test that the Mental Health Review Tribunal would look at, safe and effective, like this restrictive care is only one aspect. There is an aspect of community safety. And so that's one difference. And then the next difference is the tribunal will actually review the forensic patients every 6 months until the tribunal decided that the tribunal can stop reviewing them, or the person has served out a limiting term sentence, which I will go into further detail. So I just want to paint a broad sketch of the difference in the forensic jurisdiction of the Mental Health Review Tribunal and the civil jurisdiction of the Mental Health Review Tribunal. So sorry to jump around a little bit. So I pull back. So the first word, forensic patients, as I briefly mentioned, it is a person who's been charged with an offense, and the person was found unfit to be tried by a court. So unfit to be tried, as you can see further down, is actually one of the word lists. It's a little bit tricky, like quite often when in a lay person's perspective, when you look at unfit, yes, I'm fit, why am I not fit? So the legal definition is unfit, meaning that the person either have some cognitive impairment or mental health impairment. The person cannot understand the person had pulled back. I just pull back a little. The person has been charged with an offence, but the person, either because of mental health issues or cognitive impairment issue, cannot understand the legal process to go to court, cannot instruct a lawyer so then they can mount a defence properly. Then the court would look at it and say, no, because of this impairment, and you will not have a fair trial. The bottom line is whether it is fair for the person to go through the criminal court process. And then if the person is found unfit to be tried, then the person would go through a special, what they call a special hearing, that the person's criminal lawyer would look at the facts and the prosecutor's case to basically mount a defense to defend the person. So the person can't plead, can't go to the criminal court and say, I want to plead guilty, I want to plead not guilty. It's mainly because if they do that, the trial would become unfair. So a person become a forensic patient. Either the person was charged with an offence but was found unfit to be tried, or the person received a verdict of, there's an acronym in your handout that you look at, is APNCR. So APNCR is the long explanation, is in the third dot point, act proven but not criminally responsible. So the basic idea is that when the person was charged something for an offence, but when the person have done the act, the person, because of the mental health impairment or the cognitive impairment, that did not understand what the person had done was wrong. And with the APNCR is a verdict for, is the new name for a previous verdict that is called not guilty for reason of mental illness. The short form is NGMI. So forensic patient, for person who are unfit, but the court has found that the person has committed what the person has been charged for, then the person will give us, the judge will give a sentence. And that sentence can be, if it is serious enough, the court can give a limiting term. So if a person has received a limiting term sentence because the person is in charge of an offence, unfit, and is serious, the offence is serious enough for the court to impose a limiting term, the person becomes a forensic patient. And then the third point, when you look at the handout on the forensic patient, if the person is subject to an extension order. So the concept of extension order is in the 1, 2, 3, 4, 5, 6, the 6th and the 7th point, extension order on the screen. Extension order is that when the person has received a limiting term sentence, serve out the limiting term, the person would be, is a status, the forensic patient status would stop. But if either the Attorney General or the Minister for Health can apply to the Supreme Court for an extension order, and that order, if the court grant that order, the person's forensic patient status would be extended for up to 5 years, and there's no limit on how many times the Minister for Health or the Attorney General can seek that application. And the interim extension order is just a procedural process within the extension order application. So if you hear that the interim extension order is that once the Minister for Health or the Attorney General filed an application to the Supreme Court, they can also ask for the court to allow for up to 3 months to get two court-appointed experts to do an assessment, to inform the court, to help the court to decide whether the court should make an extension order to extend the forensic patient status of the person. And what the expert would be looking at and the court would be looking at is whether the person would if the mental health review tribunal stop reviewing this person every 6 months, remember I said that for forensic patients, the mental health review tribunal review every 6 months is mandatory until the mental health review tribunal consider that the person is safe for themselves and safe to the public before that, before the review stop, which is very different from the civil jurisdiction. So back to the court-appointed expert. So if the court-appointed expert would look at the patient, assess the forensic patient, to prepare a couple of reports to provide their opinion about if the mental health review tribunal stop reviewing this forensic patient, whether the person is likely to cause unacceptable risk of serious harm to others. So that's the public safety, aspect. So before the person's forensic patient status ends, it is for the tribunal review the patient to decide whether the person, basically to determine care, treatment, and detention. And every time they review the tribunal, they look at whether where the person is going to be placed, either in hospital or in custody or in the community under conditional release order, which you can see like under in the middle column, the last 4 points, release, and then above that is leave. So I'll explain leave a little bit. So whether the person, in principle, is whether the person should be in hospital, in custody, have leave. We need to be able to go out for some time and come back to the place of detention, or release under conditional or unconditional release. So conditional is it means the person live in the community with a support of, if the person has got mental illness, there will be support with the local mental health team as a case manager. If the person have got cognitive impairment, it would come under, it would have a case management team of, at the moment, is the community safety program, which is a public sector organization. And then that conditional release also is an order that have got about 20 to 25 conditions. It stipulates whether the person, where the person can live, which local mental health team the person is going to see, and have to see the case manager, psychiatrist, and usually the conditions would be you can't drink, you can't drink alcohol. If you move, you need the tribunal's approval, and there might be a restriction on the person, like cannot go to certain places, and the person might not be able to get in touch with certain people, like registered victims. So every time the tribunal review the forensic patients, they decide based on their assessment of whether the person have more freedom, the person would not seriously endanger themselves or any member of the public. So that's the overall regime of the forensic mental health regime. Sorry about jumping around a little bit. So now we move down to the second word. You might hear correctional patient. Correctional patient is basically an inmate, person who's either serving a sentence or on remand, that's in prison, and if they become mentally unwell and they require involuntary mental health care and treatment while in prison. So they can either, they might go to Long Bay Hospital, which is the second last dot point on the far right-hand corner. And there's also, in terms of mental health care, there's also a mental health port. We call it port, mental health port, place of detention in Silverwater Correctional Center, and there's a Silverwater Women Correctional Center. So there are various places, but it is only the Long Bay Hospital that can detain involuntary mental health patients when the person becomes unwell in custody. So act proven but not criminally responsible, I've explained that. And limiting term, I've explained that. Unfit, I've explained that. Extension order, interim extension order. So I think I've explained all of that up until, say, Supreme Court I touched upon, because Supreme Court is very the role that it plays in the forensic mental health jurisdiction is where extension order is decided, and it's also it decides certain appeal of the mental health review tribunal decisions. Likewise, Court of Appeal is appeal of some mental health review tribunal decisions, and also appeal of extension order decisions. So I'll just go to the middle column, notice of intent. So if you're interpreting in mental health review tribunal hearings for forensic patients, you would hear that this terminology, notice of intent, is basically like an application to the court, but for the tribunal context, it's an application to the tribunal. It's specified. It can be, usually is filed by the treating team, but but patient's representative can also put in that application. Basically, it's asked the tribunal to decide where this person is going to be placed, or maybe we can ask for leave, maybe we can ask for conditional release. So ask the tribunal where we would propose the care, treatment, and detention of forensic patient needs to be. So care, treatment, and detention. So I've explained it that. So mainly every time the mental health review tribunal review the patient, they look at care, treatment, and detention, and the test that they look at is risk of seriously endangering the person or any member of the public. So you hear this jargon very often. And the place of detention, it can be mental health facility, which is hospital, a mental health hospital. It can be a prison. It can be in a certain lock facility, maybe a secure aged care facility or a lock hospital ward. So those are the most common other places. And leave. Leave is another term that I've touched upon in any lay person's perspective. Before I work for mental health advocacy service, leave, yes, I can go out, yes, I can leave. No, if the tribunal said, yes, you can have leave, no, it doesn't mean that you can just go bye and don't come back. You have to come back. It means the person can go out, and it's got various types of leave. The person go out for some time and must return. And there are conditions. The tribunal can impose certain conditions, like you must carry a mobile phone, you must be with somebody, and you can only travel within certain district, a little bit like lockdown, but yeah, forensic patients, it could have, the lockdown can be a lot longer. So the different types of leave, it would start with, if you look at the handout, there's escorted day leave. Escort usually is with staff, with a nurse, and then it will progress to supervised. It will be usually is day leave, it is daytime, and it's non-staff. NDIS support worker, NDIS, everybody would know the national the NDIS, National Disability Insurance Scheme, or sometimes a friend or relatives. And usually those people, the treating team would, the doctors, if the person is in hospital, yeah, it's the hospital. The doctors would have to give that person some training, basically to keep an eye on how to support the person, to watch out whether if the person becomes, unwell, what to do, like contact the hospital, etc. So there's escorted day leave, supervised day leave. And then once the person got to supervised day leave, the next thing, the next progress is they can have unsupervised day leave. So supervised meaning you're with somebody who's not a hospital staff, but somebody has been trained about how to support the person and what to do if the person becomes unwell, like where to get help, etc. So that's what they call supervisor. And sometimes if some supported employment places, the workplace manager may agree to be a supervisor. So that's on a case-to-case basis. And then there's unsupervised day leave. That means the person can go out and do things by themselves, maybe visit parents, etc. But come back. And then the next progress would be supervised night leave. If meaning the person can sleep outside the hospital, but they must come back. And unsupervised overnight leave. Yes, okay, supervised overnight leave. It may be sleeping in a group home where there is a support worker there on site, or if a parent or a family member who's been trained as a supervisor and have got a place for the person to stay over, then the tribunal would look at each cases and decide whether the person can have escorted day leave, supervised day leave, unsupervised day leave, supervised night leave, unsupervised overnight leave. And the rule is, you will hear the tribunal set out a lot of rules. You can start with, I don't know, an hour, 5 minutes, and then if you say, oh, if you have exercised the leave without any incident, that's another term that you can hear at the tribunal. What it usually means as the proceedings progress, like you would get the idea. Basically, without any incident, the successful compliance with all the conditions that the tribunal imposed, the treating team imposed, and return on time. And it would start with small number of times to longer time, escorted with somebody, or you can just go out. The person can go out on their own and stay in overnight under somebody's supervision, or staying overnight without supervision. And so that is the hierarchy of leave. And at the end of the leave, the purpose of having this leave is to build up to conditional release. So I touch on conditional release, meaning that the tribunal trusts the forensic patient can be lived safely for himself or herself and the member of the public in a place that's approved by the tribunal, with the support of the local mental health team, which would have a psychiatrist and a case manager and take the medication, or if the person have got cognitive impairment only, like intellectual disability, they will be have a case manager from the community safety program. Some of you might know is the OCJP. So now they are called community safety program. So CJP is the public sector organization that provides assistance to people with intellectual disability, and now it's brought as cognitive impairment. So the structure have changed a little bit. So I've spoken about the condition, the set of conditions, and you will hear the tribunal say you must comply with the conditions, like have a treating team, case manager, etc. There may be place restriction. The place restriction is another condition that I've said that, like, maybe you can't go to certain places, and the technical term is the tribunal might just say there's place restriction, you can't go to, XYZ. Sometimes it may be there's the registered victim, which is like if the patient has through the course of committing, acting on that offense, have injured somebody, and then there may maybe the person, the victim of that incident, or family member, of that incident, or the person of that incident, the injured person of that incident, there's a regime, the special victim services, that they can register and they become a registered victim. And they can put up right to the tribunal and say, oh, I do not wish the forensic patient, to be around certain area. And then the tribunal can decide and put in place restriction, meaning the person cannot go within a certain area. And sometimes also it depends on the type of offense. Like say, children-related offense, and like then the tribunal can say that the person can't go into those certain places. Non-association is another word that you would come across. Non-association is not association with certain people, registered victim. And it would also, quite often, it would also include the wording like, by any means, you can't contact the person by any means. It can be like social media through another person, so you just basically can't contact.
Jo, can I interrupt? I just need to let people know, because we've gone over the time we allowed for the webinar. So just to let people know that we're probably going to need another 15-20 minutes, I think.
Yes.
We've got but people do have the handout, which has all these terms plus the explanation for them. So is there anything you want to particularly highlight that's left on this slide so we can move on to the guardianship one?
Maybe the line of sight. A line of sight may be a term. Line of sight meaning if a person go out in the community, it has to be seen by a support person, just to keep the community safe. And forensic community treatment order, that is a community treatment order that Penny has talked about, but that's an order that's given in custody to compel a mental health patient to receive mental health care and treatment. And the mental health unit for forensic patients. So there are the forensic hospital, which is high secure. Patients can't get out, can't have leave usually, except in very exceptional circumstances. Medium secure, they start to have the type of leave that I talk about, and so as low secure and Long Bay Hospital I've talked about. Additional support units, if the person have got intellectual disability and in custody forensic patient, that would be the place that they are going to be detained at. And basically they have psychologists to provide support. Okay. I think that would cover. Yep.
Yeah, great. Thank you. That's really comprehensive. It's such a huge area of work. So thank you for explaining that to us, and people have that information, and definitely they can contact the Mental Health Advocacy Service if they need help to understand that. So the next slide we've got coming up is the guardianship mental health words, and I think, Penny, you were going to start us off with this list of words to take us through.
Yep, I'll start you off, and it's not my strongest area of expertise, which is good because it means I won't talk too long. Also, something that just with that forensic stuff, one thing that comes up a lot for people is the confusion, because the forensic hospital is located right next to the Long Bay. It's kind of like on the same block of land, I guess, as Long Bay Correctional Centre, right? Long Bay Jail. Long Bay Hospital is within the jail. Sometimes we get people getting confused because sometimes people refer to the hospital at Long Bay. Sometimes they're referring to the forensic hospital, which is not part of the jail. Sometimes they're referring to Long Bay Hospital, which is part of the jail. Very important distinction to make, just so that everyone knows that.
Great, thank you.
Okay, so yep, guardianship. I'm just going to get my notes up here. All right. Sorry, hold on. I'm going to move it over so I can still see you.
So earlier on in the webinar, Bridget did talk about the NCAT and the guardianship division. So maybe you could start at subject person.
Sure. Yeah. Okay. So so you've got the guardianship tribunal, which is just kind of like a specialist part of NCAT. It's its own little tribunal that's part of NCAT. We've talked about members. If people want to refer to someone who's sitting on the tribunal, and this is the same for the MHRT, the Mental Health Review Tribunal, we refer to them as members. Although sometimes they introduce themselves and tell the person that, or tell the people who are at the hearing they can refer to them by name, which is nice. But if in doubt, it's member. Okay, so the subject person is basically the person who the guardianship order is going to affect. Okay, so it's the person, who's going to be the subject of the order if the order's made. I think that's pretty clear. Generally speaking, people aren't legally represented in the guardianship tribunal, and if they want to be legally represented, then they have to actually ask, or we ask on their behalf, for leave from the tribunal to have legal representation. And there's a list of kind of considerations that help the tribunal make a decision about whether the person can be legally represented. Now, that's where, when we talk about that kind of representation, that's called direct representation. So that means the subject person contacts us and says, I don't want this order, I want to fight it, I don't really know anything about guardianship, I'm a vulnerable person for these reasons or whatever. We talk to them and we agree that we will help them to defend themselves against the order. That's direct representation because we're acting on the subject person's instructions in that case. Separate representation is different. Separate representative is still a lawyer, and the lawyer still talks to the subject person if that's possible, and is basically assisting the tribunal, though, not representing the subject person. So they're assisting the tribunal by kind of going behind the scenes before the hearing, getting the subject person's views and feelings about it all, talking to the other people who are involved in that person's care or who are concerned for their well-being, and then assisting the tribunal in the hearing to make a decision that's in that person's best interests. So, it might be that the subject person tells the separate rep that they don't want the order, but it's pretty clear from looking at all the evidence and talking to all the other parties that really the order is justified. So the separate representative still make sure that the subject person's views are heard by the tribunal, but their role is not necessarily to do what the subject person wants them to do. The parties, that's the same really as in any other area with a court or tribunal. That's the people who basically have a right to be heard about the order or to attend the hearing, to get copies of evidence, get copy of the order, that kind of thing. They, in the guardianship area, sorry for background noise, I have a small person in the room with me, that's a person with a genuine interest in the welfare of the subject person. So it doesn't necessarily have to be someone who's treating them or related to them, but they have to have a kind of a genuine concern for that person's well-being and have some involvement with the person, and they can be a party. Evidence, I think, again, just the same as in any other jurisdiction, the information that the decision's based on. A guardianship order, so the guardianship order is, it's only made if there's a real need for it, if it's going to serve a purpose. So, the tribunal might find that a person is not really able to make good decisions for themselves. But if there's a kind of a structure around them that already helps them with that, if there's someone who's already helping them with decisions, that kind of thing, sometimes there's no need for a guardianship order. So there has to be work for the order to do. And the order is based on whether or not the person has a disability that impairs their ability to make their own decisions and look after themselves and, live their lives healthily, and also whether the person has capacity or not to understand the pros and cons of decisions, and, so to make informed decisions, I guess, in their lives. I think that kind of sums up the concept of capacity or incapacity. So if the person's found to lack capacity or to suffer from incapacity, then yeah, that means that they're not able to make their own decisions. So the guardianship order will be made in terms of the concept of functions. So a guardian will be appointed. Usually they try for that person to be, you know, not the public guardian. So a private person is the kind of default, the ideal. You know, so a person who's already has a relationship with the subject person, who the subject person trusts, and where, I mean, sometimes there's a situation where, you know, it's, even though there is a person who could play that role, like a parent, for example, or a child, if the tribunal thinks that conflict could be caused by that relationship of there being a guardian and someone making decisions for the other person, then that might be a reason not to appoint that private person. But the tribunal is obliged to go for the private person option first. If there's no one, then a public guardian is appointed, and that's the person who gets to make decisions on behalf of the subject person in relation only to the functions that they are given. So the functions are like the powers that the guardian is given to, you know, the aspects of that, the subject person's life that the guardian is allowed to make decisions about. So the functions usually are, and there can be an accommodation function, so they give consent to the person living in particular accommodation to receive services, to receive health care, consent to medical or dental treatment, and also they can have an advocacy role, and they could give consent to something called restrictive practices. Restrictive practices are, like Joe referred to, line of sight. That's considered a restrictive practice where a person can't go out in the community unless they have someone watching them. Line of sight is a very specific term, which means that basically the person who's supervising cannot lose sight of that person. They have to follow them into the toilet cubicle, right? Like they have to, you know, or at least into the toilet and be able to see their feet. It has to be, you know, their eyes on. It's different to just supervision. But so that's an example of a restrictive practice. That's, and we talk about various types of restraint that can constitute a restrictive practice. So you can have environmental restraints, like the person can only have plastic cutlery in their accommodation, they can't get access to sharp things, their access to the community might be limited, the doors might be locked, they might not be allowed out except under certain circumstances. Sometimes they have, you know, like there's chemical restraint. So there's, the person might be administered medication to moderate their behavior. And there's actual physical restraint. In some cases, people are able to be physically, you know, restrained, their movement physically inhibited. Yeah, so I mean, those are quite extreme things. But yeah, so the guardian, that can be one of the functions of the guardian, to approve those kinds of restrictive practices. There can be, then there's also something called coercive powers, or an authorise others power, which usually refers to accommodation, where not only can the guardian authorise or consent to a person living in a particular accommodation, let's say a nursing home, but if that person leaves the accommodation, they can actually be kind of compelled against their will to return. So ambulance or police are authorised to actually bring them back by force if necessary. That's a coercive power, but in the order it's expressed as authorising others. So the guardian can authorise others to bring that person back to their accommodation. And I don't know that I've got override objection on the list, but it's listed in the table. Essentially, so it allows, so the guardian can override the subject person's wishes. Essentially, they have the power with an override objection to say, well, that person wants to live here, but I'm overriding that. They have to live there. That's an example. Or actually, oh no, take that back. Sorry. So, told you it wasn't my speciality. I think the override objection specifically relates to services and medical or dental consent. Okay. Yeah, so that can consent to medical treatment, for example, where the subject person doesn't want to have it, but the guardian can override that. Okay, so I think that's me, and then I was going to hand over
To Joe.
to
So
Joe.
Joe,
Have
you're
I
going to
missed
take
anything
us
important?
through the
Yes.
rest of the words on this slide, starting at
Yeah.
enduring guardianship.
Yes, that's right. Enduring guardianship. So the difference is that the person actually, when the person has capacity, the person actually sign a document to appoint a certain person to make decision, or where they live, what services they have, healthcare, dental, medical consent, in the event that the person lost capacity. So if the person does not have an enduring guardianship in place, and if there's conflict, then anybody who have got the concern of the welfare of the person can apply to the NCAT Guardianship Division for guardianship order. So that's one way of not bypassing, don't need to have a guardianship application. Financial management order is an order. Quite often people get confused. I think a person is under guardianship. Oh yes, I can manage the money. No, finance is two separate issues. Like guardianship order deals with substitute decision about where do you live, accommodation, healthcare services, restrictive practices, and dental medical consent. And financial management order is when the person because of disability, is not capable of managing the person's financial affairs. It's a separate order to manage the person's estate, and the order can be for part of the person's estate, and it can be a private person. Again, like what Penny said, if there's a private person, no conflict of interest, the tribunal would try to look for a private person. If there is no such person available, then it will be the New South Wales trustee. And the estate is the person's finance, including the income, expense, asset, debt, legal liability. So financial management order, as I said, it can be for the entire estate or part of the estate, and quite often the tribunal may exclude the person if the person receives a Centrelink pension, might exclude the person's Centrelink pension to allow the person to manage the pension. But if the person's, it depends on the person's capacity to manage, because if it's management of the entire estate, it's sort of like de-skill the person as well. And if the person's only receive a Centrelink payment, then either way, if it is managed by the financial manager is the New South Wales trustee, the trustee would give the person allowance, maybe twice a week, X amount deposit into a bank account, and the person would have to withdraw money. And the person, if they need extra, they would have to apply and talk to the New South Wales trustee to get extra allowance. So power of attorney is like the counterpart of enduring guardianship. It is a document when the person have got capacity, they can actually sign and witness, appoint somebody to manage, to do things for them. Like, it can be temporary or permanent. And there's two types of power of attorney. It can be just an ordinary power of attorney when the person's, away on holidays, can't deal with bank accounts, so authorize somebody to do that, or it can buy or depends on the power that is written in the power of attorney. It can be covered buying and selling real estate, etc. And the important thing is there is an ordinary power of attorney, as an enduring power of attorney. The enduring one, actually in both the context of enduring guardianship and enduring power of attorney. It is when the person lost capacity that kicks in. So the enduring power of attorney, it can be, just when the person lost capacity, there would be a doctor report saying that the person lost capacity, and then the person who is appointed as the attorney can start managing the person's financial affair in the way that is stipulated in the enduring power of attorney to help the person without having to have a financial management order. It is approved by the ANCAT Guardianship Division, because a guardianship, a financial management order, can be temporary for a short period of time, can be reviewable, and it can also be non-reviewable, last in perpetuity until the person has regained the capacity. That would require an application to the ANCAT Guardianship Division to revoke the financial management order. And I just like to also sort of feel, we go to the review. So that is, so financial management order, it can be reviewable. If it is reviewable, the tribunal can, of its own motion, to review it. The person have got concern about how the person's money is being managed by the trustee, by the private financial manager. It also can apply to review for a review. And on the review, the tribunal can confirm the financial management order, revoke the financial management order, vary the financial management order, can carve out maybe, if the financial management order was for the entire estate, and then if the person, there's ground that the person should have got a capacity to manage part of it, can carve out certain portion. And likewise for guardianship order as well, the initial guardianship order, the tribunal tends to make a 12-month order and is reviewable after the 12 months. But under the law, it can be 1 month, 1 year. Sometimes it can be 1 month. So there's be a reviewable period, and then it can be reviewed and then extend for a maximum period of 5 years. So it lapses. The guardianship order is that it can lapse if the guardianship, if the ANCAT Guardianship Division does not approve an extension of the guardianship order. Person responsible. So person responsible, if under the guardianship application and the guardianship, the ANCAT Guardianship Division thinks the person needs somebody to make substitute decision in the health care or give consent to dental or medical consent, it is an area that the tribunal would like to preserve for person responsible. So the definition of the person responsible, it is parent, spouse, unpaid carer, close friend or relatives, or if the person has appointed an enduring guardian. The main thing is if the person is caring for the person for remuneration, that's not a person responsible. I think I sort of have wrapped up.
That's it. Our last word is close and continuing relationship.
Okay, person have a close and continuing relationship is just, I think it's covered. It's like the parent, spouse, close friend and relatives who's like care and look after this person, but cannot be paid, cannot be a paid carer. It's very similar to the distinction for the person responsible.
Okay.
Yep.
Great. Well, I think we've got to the end of all our words, which is amazing. Thank you both.
Sorry, Jo, I
Jenny
kept
and
going
Jo.
first, and then I took up the time.
No, okay. It's been. There's a lot of words in the work that you do that's quite unique to the work you do. So thank you so much for sharing those words with us and explaining the processes and the tribunals. So we will bring this webinar to an end. That's just to say we've got another one coming up on Thursday morning, which is looking at family law. There's already a lot of people signed up for that, so I'm assuming most of the interpreters are already signed up, and that's pretty much it. So the slide coming up is just to say thank you, first of all, to our presenters, Bridget, Penny and Joe, and also, of course, Olivia, who had left midway. And if you're watching this as a recording, you can send any questions you might have to cle@legalaid.newsouthwales.gov.au. But also the handouts, we will load those up on the recording site as well. Those handouts are there on the control panel, which you can download. Well, I'm about to close the webinar, so you'll lose that opportunity if you've done that, but I have sent those out by email. So thank you everyone who stayed with us for a little bit longer, and we hope that you've learned quite a lot. We're getting lots of thank yous through the question panel, which is great. And after the webinar on Thursday, that'll be our last in our series for this year, and we'll be back in 2022 with our Legal Words for Interpreters webinars. And yeah, so we look forward to welcoming you all to our next Law for Community Workers webinar. So I'll say goodbye. There's no more questions, so it's all good. So see you later.
Thanks very much,
Okay.
Kerry. Thanks,
Bye.
everybody.
See you.
Thanks.
Thanks, Kerry and
Bye.
Bridget.
Thank
Thanks.
you.
Bye.
Thanks, everybody.